Hello, everyone, veterans, dedicated VA employees, everybody watching. Here we are, just trucking along in 2025. We've made it through 1 month, and we're about to go through another. I hope everybody's doing great. I hope it's been a good 2025 for everybody to this point, and then I hope that it continues to be. And if it has not, I hope for the improvement of it all for you, and hope that the year only gets better for you. So we're here to talk about VA disability. My name is Attorney Matthew Lang, VA accredited attorney. Years of experience as always with the VA disability realm. So I'm going to take a topic today of the duty to assist with providing medical examinations. I'm going to do it from the approach by discussing what's in VA, your M21-1. Particularly, we're starting with Part 4, so Part 1, Chapter 1, Section A on this one. Now, this is not to veterans just a manual for only the VA to see, but it is the manual that the VA uses to help guide them. It's not a terrible tool by any means. I used it a lot myself, and sometimes I still use it today to help understand why certain things may have been done the way they are. Now, the tool is only as good as the writer, in my professional opinion. I do feel that there are, in some areas, flaws that do not line up the law within the manual. But again, overall, that doesn't necessarily make it a bad tool. So veterans do know you can find it out there. I like to Google search it. I kind of be careful with other search engines because I found they don't do very well on the search for some reason. But type in KNOW space VA. You should be able to find it. It's no VA altogether there. ebenefits.va.gov, and you'll find a page that actually has multiple resources on it, but you'll find the M21-1, this manual on here. Okay, so now that we got that figured out, that's where we find it. So I really want to take a peek at this piece here, and we will likely later on go down the roads and look at the other rules and laws out there, because this is just some guidance that's been put out there. But I want to look at this here because, yeah, I know I've made mention a few times and really kind of highlighted that examinations seem to be a rough point within the VA system. Knowing when to schedule them, when not to schedule them, knowing when they're adequate and when they're not adequate. So I want to look at your guidance with you. I want to go through this here. I want the veterans to see what your guidance is as well. And I would encourage comments and your opinions on how you even read this or see this. I'm going to give you my point of view. And as we talked in other videos before, this is only one perspective. This is a perspective based upon my experience, my knowledge, and the training that I have done within the VA, my legal education, my legal background. So take it as you will. It's really your choice on how you want to take this. But I'm really hopeful that in the end that we can come together in understanding a little bit better, at least, how to and when to schedule these examinations. Now, as mentioned, this is a duty to assist issue underneath the law for the VA, which means, yeah, underneath the VCAA Act of 2000, VA, you are responsible for scheduling and requesting VA examinations when the evidence and the documents of the Veterans VA claim file require you to do so in order to assist the veteran with their claim. So let's look at what the purpose of obtaining a medical examination or opinion is based upon the manual here. This is really kind of what it reads, and you can go back and read all this yourself, and I actually encourage it, veterans and VA employees and everybody watching, so you actually can see it for yourself on what it says here. I'm unfortunately not the tech savvy. I think it'll get there one day, so I don't have all the fun stuff that shows up behind me back here and all the switches between screens and all that. I think I've tried it a few times and maybe it's worked, maybe it hasn't. But anyhow, purpose of obtaining a medical examination or opinion. So here in the manual, it tells us that the submission of a substantially complete claim triggers the duty of the VA to assist a claimant in obtaining a medical examination or opinion when necessary to substantiate the claim. So immediately it almost sounded like, oh, second file a claim, duty to assist is triggered. We got to get an exam. Well, as we can hear though, necessary. What are we talking about? What's necessary? And we'll see if it says it in here. We'll find out what goes through here. The next part really kind of tells us there's an exception. That's kind of fun for me, as we mentioned before, that law has got exception after exception after exception. So even the manual here for the VA has exceptions. And I'm going to take a little bit of beef with the exception. I'll be honest with you, VA. I'm going to take a little bit of beef on this one. So again, this is based upon my experience, my knowledge, my education, and my background, and how I'm going to interpret this. So the exception says an examination or opinion is not part of the duty to assist in a supplemental claim unless new and relevant evidence is presented or secured. I don't fully agree. I'm not saying it's wrong, but I can't say I fully agree with that. And I think this is where we got to step outside and start looking a little wider at certain things. So as you heard me in the first paragraph, you kind of heard how it could be interpreted one way, like, oh, automatic, but then yet it's not. Then what's that mean? So I think what we have to look at is, sure, on the surface, perhaps, if a supplemental claim is filed and is submitted, and there is no new and relevant evidence, you want to say that there is no duty to assist triggered. But what about the duty to assist that was triggered previously that was not followed through with, VA? What if that supplemental claim demonstrates, without new and relevant evidence, that a duty to assist error occurred in a previous decision, and the only avenue the veteran has is the supplemental claim in order to identify and trigger the duty to assist? Sounds like that it is possible with that kind of logic and reasoning that just because it's a supplemental claim doesn't mean a duty to assist cannot be triggered without new relevant evidence. Now, perhaps there's a further explanation somewhere else. Maybe not. But as we read it on the surface, just know that's the point of view. Keep it in mind, is all I ask. It goes on, the purpose is to obtain medical evidence relevant to establishing entitlement to benefits when the evidence of record is not sufficient to make a decision, such as information about diagnosis, onset, or etiology. So maybe that's kind of our necessary part. Maybe. Could be. And I think it touches on it for sure. So the idea is that an exam would be necessary if the evidence of record is not sufficient to make a decision, such as information about a diagnosis. Now, it does say such as. Keep in mind, it does say such as. It means this is not an all-inclusive list. So then do we go back to the idea that the second it's filed, that the claim is filed, that we have a duty to assist for an examination automatically? Because when the claim is filed, you have to ask yourself, if I'm missing a diagnosis, I'm missing an onset, I'm missing an etiology, if I'm missing all three of them, I don't have sufficient evidence to make a decision. But none of them usually exist right away when the claim is filed. It's an interesting thought. Maybe it's too far. But my idea here, everyone, is I want you to think about what you're reading. And maybe I'm overthinking, perhaps, on that one. I think really the basics here, without adding additional confusion, is that we need, the necessary is really, is there something, an element missing that keeps the record from not being sufficient to make that decision. And I think typically what we'll find in the manual, even as we dig through it more, and especially in the law, is that what it's talking about is the idea that if we have those basic three elements again, and I can't hammer those away enough, the idea is that we have a potential etiology in service, but we're not really clear of the diagnosis. And now, veterans, you don't really need to know what your diagnosis is. I mean, you are deemed competent underneath the laws and the rules to say that you feel pain in, say, your knee, and that it is plausible. We know it's plausible due to many training exercises, PT, combat missions, MOSs. Maybe it's even the etiology could be potentially documented in STRs. You went to sick call, you went to medical. That could be even really the potential onset of it all. So I think the idea is when we're missing really one of those elements, and then like we're looking for that current diagnosis, but we're also looking now for that nexus. Yeah, maybe we can say that now we don't have sufficient and becomes necessary. Maybe that's the way it's trying to read. But they give you some more information in there, help you kind of dig it out a little bit more in that section. But let's move on here to the next section of this reference here. So this is the regulatory standard for finding examination or medical opinion is necessary. Oh, look, now that we've already kind of went through our little thought process, maybe some speculation of what does all this mean, we do have a section as we keep reading what necessary should mean. Let's find out. So the regulatory criteria for finding examination or medical opinion necessary under the duty to assist are in 38 CFR 3.159 C4. I'm not going to disagree there. You can find it there. What's nice, veterans, is and VA dedicated VA employees, if there's a link there, you can even click and you can actually pull up that reference and you can read it yourself and see what it says. A medical opinion or examination is necessary when there is not sufficient medical evidence of record to make a decision on the claim. Okay, we've established that in the last one, so it's appreciated that's said again. Sometimes repetition is needed. And, well, now there's an and. Let's check it out. There is competent lay or medical evidence of a current diagnosed disability or persistent or recurrent symptoms of disability. We have another bullet point. The evidence establishes that the veteran, and then it kind of goes down to suffered an event, injury, or disease in service, or has a disease or symptoms of diseases listed in all multiple sections there. We're talking, looks like a lot of presumptions manifesting during application. Presumptive period. Yeah, those are the presumptions. Period. And the evidence, which is interesting where that and might kind of land, I suppose. But and the evidence indicates that the claimed disability or symptoms may be associated with the established event, injury, or disease in service. So basically, that's what it was. That's what it was. It's really what I was saying before, and I kind of got ahead of myself, honestly, with that one because that's what the rules say. So really, it's necessary if there is evidence of the record, whether it be lay or medical evidence, that there could be a current diagnosis, there is a current diagnosis, there might be symptomology to be related to a diagnosis, and that the evidence establishes, again, that plausibility of an event in service that could be related to that current diagnosis there, or so forth. So it really kind of starts explaining it out there. Now, it does say important here, and I want to highlight this VA for you. I think this is a crucial piece. Important examination and or opinion is not warranted until all three elements described above are present in the evidence. Now, I have seen in decisions, VA, that you will deny a claim and say that the veteran hasn't provided any evidence that shows that their condition is related to their service. Essentially, you're saying they didn't provide that nexus statement. But now keep in mind that important piece there. It says from above. So you have to look at that again. We're not requesting that the veteran provide that nexus statement in order for you to schedule, well, a nexus opinion or a VA exam. The idea is we have, again, plausibility of and evidence that could potentially link a current diagnosis or symptomology to some sort of in-service event, whether that be the combat, whether that be an MOS, whether that be a documented injury, whether that be a competent lay evidence recounting an injury that was never documented properly in service treatment records. So keep that in mind, VA. I just want to point that out because I do see this in more than one denial. So it is important that when it does say an examination or opinion is not warranted until all three elements described above are present in the evidence, doesn't mean that the veteran is required to give you that nexus before you schedule the exam. So you'll get some other references in here. You'll get some other, they'll even cite a couple of court cases in here, I think is good as well. I recommend reading them. I recommend going through them. I don't want to go through them all in great detail. I just kind of want to give you, everyone, a rundown of what's kind of in this manual. And I want you to just kind of see how I'm looking at it and what I'm thinking as I'm reading it, and give you the chance to go, nah, he's crazy, man. Or just say, you know what? That makes sense. I think, again, it comes back down to perspective. Now, I'm really VA. If you're really paying attention, I'm really giving you some of my magic back here. I'm giving you some of my arguments on, especially when I argue veterans. I guess there you go. If you want to follow yourself, there's maybe a potential argument for you or two in there too. So let's go to the next section here. Reviewing evidence before determining an examination or opinion is necessary. So we start off with an examination or opinion is only necessary under 38 CFR 3.159 C4 when there is not sufficient medical evidence of record to make a decision of the claim. I have now read that, I'm pretty sure, 3 times in one way or another. That has got to be important. I feel like the top echelon somewhere, or whoever is writing this thing, is really trying to get to the point, VA, that please, only request an examination or opinion when there is not sufficient medical evidence of record to make a decision on the claim. I see that as a problem, though, still. Like for some reason, many cases I get, now I will admit, I get the bad and the ugly from the VA, because if it was good, well, no one's going to be coming to me trying to appeal a claim, right? I get it. But if this has been repeated so many times, I think it's something that says I'm stomping my foot. It's probably important. So I want you to look at that. And maybe we'll just kind of hit on that a little bit as we go through. But before I get carried away on any soapboxes, I want to see if it kind of pops up here. Now, the reference goes on and talks about 38 CFR 3.326 as well. Similarly provides that examination is authorized when medical evidence accompanying the claim is not adequate for rating purposes. To illustrate the principle, the regulation adds that any hospital report, any government or private institution examination report, or statement from a private physician can be used to decide a claim without examination if adequate for rating purposes. Now, see, that's a good thing I didn't get on my soapbox right away because it's right there. Adequate is definitely the key term in there, and VA, I think you really misunderstand what adequate is multiple times. Whether maybe it's a training issue, maybe it's the idea that you're rushing to get production points. I could say from experience there might be a little bit of both involved, but I'm not here to speculate. I'm not here to beat you up. I think what we're really looking at here is that you are responsible, VA, to go through, and you really owe it, I feel, to the veterans out there that you're responsible for going through every piece of evidence. Look at it. There are times, for various reasons, I know veterans who will not seek treatment at a VA facility. They may go to a private provider. Well, that private provider may not know the VA way, and they do their best to provide you with what they're understanding. Now, that could create an adequacy issue, and I got that. But let's say we turn the table on that one. And let's say the veteran does get their primary care from a VA provider, a VA clinic, a VA hospital, whatnot. Well, the medical world doesn't always talk well with the legal world. So we've created these DBQs in hopes that we can make them talk better to each other, because a lot of stuff I find that the law wants, medical providers are not really putting in their reports because, well, it doesn't make sense to them. I get it. Two different worlds. So sometimes we find that those private providers, even within the VA walls, uh, are unwilling to do a DBQ for a veteran. So veterans, I get it. Maybe you seek out somebody else to do a DBQ for you, somebody who does a review of your medical evidence. You are able to download that information from the portal online through the VA. Everything is documented in there, especially your VA treatment records. You could easily take those off to another provider and go, may you review these? And they may ask you your questions, and they'll likely examine you as well. It would be like, I like to incorporate it with the idea of urgent care, as those are fairly popular, I feel, today. You're looking for somebody who can just take care of you in the moment and not necessarily forever. Now, what happens is we get these DBQs back, and many times they are adequate. And I think VA, that's where we run the problems, because then really you're in violation of this duty to assist in a sense, because you refuse to accept them without reason. Again, I see the good and the ugly, or the not necessarily the good, but the bad and the ugly. You will reject them. Some of you, I will see, try to give a reason. You know, I'm just back here looking at the piece of paper or the screen, wherever I may get it at, crazy, because I can't believe you tried to inject what appears to be your personal opinion when, again, the law says not to. Or you came up with some weird conclusionary statement that doesn't make any sense. Now, again, does it happen all the time? No. I worked with a lot of great people in the VA. There's still a lot of good things that come from it. But again, I'm pointing out the bad and ugly VA for you to be aware of it and know it's there. I want you to think about, hopefully, hey, look, he's got a DBQ. Let's go back and see what the courts say are adequate. Let's go look at what the law says is adequate. Let's determine, is it truly adequate? Remember, grant if you can, deny if you must. If you can't find an inadequate reason on legal inadequate reason on the surface quickly, it's probably adequate, I would say. Why go searching for a reason or making up a reason to ignore it and schedule an exam that you don't need and then go outside of your duty to assist? Okay, soapbox over, right? It's not about soapboxes. I will definitely fall down on them. A lot of passion, I feel, in doing this job. So keep in mind, there's some more information in there. There's a lot more information in there with a lot of references. Again, I'm running long on our video, but I really want to kind of get some of this hashed out just a little bit. So we'll move to the next section here. Is timing of an examination or opinion determines when other development is required. So the timing for determining when an exam or opinion is necessary under the duty to assist, and then requesting examination or opinion, may vary case by case and can depend on other required development. As a general rule, apply the following principles unless there is specific development guidance to the contrary that is applicable to a particular type of claim. And it really kind of goes through all that. And what does that really mean? I think we would have to really dig deep in this one, really look at it, and make a determination. So I'm going to kind of skim this one a little bit because it's a little bit longer, but I think the idea here is what it's saying, and what it kind of said that I skipped on the last one a little bit too, so you can go back and read, because lack of time and so forth. But it's the idea that not every piece of evidence necessarily needs to be in the file in order to request the exam. And I see this sometimes with VA, and I know you get cautious and you want to CYA. You have quality to deal with as well. You've got other supervisors to deal with. You've got whatever it may be to deal with. And I've been down that road. So you may just go, well, I don't have all the development yet, so I'm not going to schedule the exam. But no, well, the concern that lands there is you may be unnecessarily delaying a claim. There may be enough to at least get started with the exam and go from there. And I think that's what these two sections kind of talk about. But now you do have situations where you definitely can't get the exam. And I think it's important to note that, because it's also important here. in this section. One thing is that the service treatment records, the STRs, must be a record. They must be a record unless, after all required efforts, they are unavailable. So do note, veterans, even the VA may not be able to start their duty to assist process yet because, again, something's missing and it hasn't triggered quite yet. And that's one of those big things. Now, that's a huge piece because it's talking about what's in your service there. There's definitely some more in here, but I definitely want to highlight and kind of give you the idea. Like I said, there may be pieces missing where you can't do that exam. But if we have STRs, we've got some lay evidence, maybe we can go ahead and get started with all that stuff. We'll have to read what it says further. Give some definite examples in here and stuff too. I'm not here to beat anything up. I just want to get you familiar, everybody, with what's here. Now, we get into some actual detail here, veterans. It tells the VA in this manual a lot of times what to do with inside their system too. You kind of get a feel for that. I know you can't see their system, but it kind of gives you an idea of what they're supposed to be doing. Now, who can see inside their system besides the VA? It's myself. So, veterans, here's my plug. As always, there's always one in here. Do not forget there are accredited representatives out there, whether it be myself, another VSO, another accredited agent, another accredited attorney. Understand, as long as we're accredited, we should have access to your file in full, and I can see the actions that are taken inside that file, including notes. Not only can I see that stuff, but as I liked to tell everyone, as I help give birth to the program they use today, so I have a higher level of understanding of that system and what's there. I can usually get an idea of what was clicked on by looking at the system too and what was done. Now, does that make me better than any other representative? Not necessarily. But I just want veterans to give you that idea that finding representation may benefit you as well. But again, it's your choice because there's more we can see that you can't see in the background. Keep that in mind. If you want, veteranlang.com, phone number's on there. It's really easy. Actually, just click the link, schedule a consult that fits your time so we don't play phone tag as well. But you got your options there. If you're in the Arizona area, 13991 West Grand Ave, Suite 100, here in Surprise, Arizona, by the VA clinic is our new office. We're hoping to get the signs up on the building if they're not up by the time this video posts. So you may not find them. They'll be the only building without signs if you pull up. Walk in, see if I'm available, see if any of my staff is available, and we'll get you on the calendar if we can, or get you taken care of right away. Also, go check out those other attorneys as well. Go check out those other VSOs, other accredited agents. They do great work as well and are there to help you in the process. All right, enough of that plug. I'm not here for all the plugs. But you'll see in this section here is that point here as it goes through a chart and a bunch of steps and actions and so forth. So I think it would be neat to see if I was the veteran, kind of what that is. It may not make total sense since the system's not in front of you. But VA, to remember, it's in here in case you need to refer to it to help you walk through it. That's really the whole section right there, actually. That's that whole section of the manual, everybody. That's M21-1, Part 4, Subpart 1, Chapter 1, Section A. That's the duty to assist with providing a medical examination or opinion. Now, I want to note, though, VA, not a bad reference, but I'm not so sure it gave you everything that the law requires. And it may not be able to ever do that just because that's the way things work. And I got that too. So, veterans even and dedicated employees, keep in mind, when you go through these sections, it's okay to ask them those off-the-wall questions it may feel like that I asked at the beginning and start to wonder, is there a court case out there? These cases that are referenced in here, are there newer ones that haven't been put in the manual yet that say something more? Are there other sections of the law? Has Congress passed a new portion of the law? Have they updated the United States Code? Has the CFR changed? What more information can I find? What I've always tried to tell people that I've trained, veterans and dedicated VA employees, is always be curious. Always be curious. We're not cats. Hopefully we have more than 9 lives, but just always be curious. but don't be so curious also at the same time. It's a balancing act to fall down unnecessary rabbit holes and be confused on where you started at. Guilty, right? Anyhow, everyone, I thank you so much. This was a look into a unique way of duty to assist, again, with those medical examinations. I want to see if we can't, over time, make more sense of this, because instead of me sitting here yelling at, saying and pointing out that this is a problem, let's try to find a solution. Let's look at it. So I'd be interested in any comments that anybody's got. Go back and read this. Kind of give me what you thought of when you read it. Let me know. Let me know what you think, veterans. That would be in place if you're comfortable. Again, I'm not trying to put you in an awkward position, but if you want to throw a comment on there and how maybe you read it, help us all understand the different perspectives. With that, don't forget to subscribe, to like, to share, to get the word out there so we can build this platform and teach more about VA disability and talk more about it and making a smoother process for everyone. All right, everyone. Thank you. I will see you next week. Have a wonderful day.